Do you want to learn how to get retired, stay retired, and enjoy your life to the fullest? This is the Retire Happy Podcast with certified financial planner professional Jeremy Finger. Jeremy will be your guide to happiness as he discusses the art and science of retirement, breaking down the complicated information to help you make good financial decisions without worry or burden. Now, on to the show.
Hello and welcome to Retire Happy with Jeremy Finger. Jeremy, what's going on?
Oh, just living life, helping people get retired and stay retired.
I like that. I love it. That's good stuff. Hey, I know you've got a guest on the show today, and for those that are actually seeing us on YouTube, you can see the guest as well. Who'd you bring on the show?
I brought a good friend of mine, Tripp Wiles, out of Charleston, South Carolina. He's going to share with us high-level estate planning topics and some things that people can do to help their estate in multiple different ways.
Well, you said the magic words to me, Charleston, South Carolina. That's my favorite place. So I like them already. I'm excited to hear what you guys are talking about.
Yeah, we are too. And excited to have him on the show. Yeah, let me introduce Tripp Wiles from Charleston, South Carolina. He was born in Charleston, South Carolina, grew up in Tennessee, and he graduated from the Citadel. He was also in the Army, and he served in Germany and Macedonia. He was a research analyst from the U.S. Army Central Identification Laboratory in Hawaii, and Defense POW Missing Personnel Office. He is an author of a book called Forgotten Raiders of 42. He was appointed by Nikki Haley to serve on the Charleston County School Board, and he has assisted many, many, many families in preserving their legacy through customized estate planning. Thank you very much, Tripp, for being on the show.
Well, thank you for having me, Jeremy.
Yeah, our pleasure. So a lot of times people have their base level planning done. Let's say they have their wills and their power of attorneys and things like that. But what are some of the things that you do in helping people think about the next level of estate planning?
Yes. Well, I find that unfortunately, most people don't have planning in place. And those that do, as you mentioned, it's typically simple planning that they may have done when they were younger, or it may not have been as comprehensive as it needed to be. It may not have been coordinated with their financial advisor and CPA, et cetera. And they may have just outgrown it. So we try to help people. We boil it down to what their concerns are rather than the documents. When people come in and say, I need this document, I need that document, we try to say, well, let's start first and talk about what your plans are, what your goals are, what your concerns are, because everybody's different and everybody's concerns are different. And, we want to help them ensure that they're meeting those concerns and the plans reflect what's going on in their lives. And there's also some things a lot of people had not considered that we may or may not resonate, but we bring up some of those concerns that we've seen in similar situations. And a lot of times is a way to really help their family and help their planning.
Yeah. All right. That makes sense. I like how important is it, or what are some of the things that would be important for a financial advisor or CPA to know in coordinating with the estate plan? What are some dangers if that doesn't happen?
Well, there are a lot of benefits that can be used with planning that go beyond just titling. Unfortunately, a lot of people look at their assets and they say, okay, they're titled jointly with my spouse, so I really don't need to worry about doing any advanced planning. But what they don't realize is they're going to be missing out on some tax planning opportunities and really protection opportunities for families. And so our motto is to help people plan, protect, and preserve. That's plan for your family, protect your assets, and preserve your legacy. And in order to do that, you have to go beyond the simple planning. So for CPAs and financial advisors, I think it's really starting with the assets, because the assets and the concerns do drive everything. So how are the assets titled? If the clients have a trust, are they aligned in the trust? What is the trust saying? Have they been updated according to current tax law? Have things changed in their lives? If things have changed in their lives, then the plans need to change as well.
Okay. Like, for example, like you mentioned, in a joint account, a lot of people have joint account. They don't. But what are some things that they would be missing out on the tax planning side if they had a joint account, if they had a decent amount of money in it?
Yeah. So when it comes to tax planning, I think a lot of people, because the tax law changes so much, and when I'm talking about tax law, mostly I'm speaking to estate taxes. the estate tax has changed 7 times just in the century alone. And those are just the major changes. So, right now, someone can pass away with $12 million and not have an estate tax. And that includes everything. That includes real estate, life insurance, retirement accounts, bank accounts, cars, you name it. But that number has been as low as $675,000 just in this century alone. And there's been threats of it going down much lower than it is now. And if Congress or the president doesn't change the law, it will automatically go down to 6 million in just a few years. So most people are not thinking about that. They're not keeping up with that. And because of that, if everything is just jointly titled, even if they have a plan that has tax planning, there's a very good chance when the first spouse dies, which, by the way, is usually the husband, the wife is not going to use her estate exemptions because she may not be aware of them or the plan doesn't call for them to be used. When a husband passes away at a very high exemption, everything may be okay. But if the law changes when the wife passes away, then there's a very good chance the children are going to have to pay estate taxes. And those estate taxes are due very quickly. And a lot of times there has to be a fire sale on property, investment accounts, you name it, in order to pay the government. So the funding and the titling really help when you have the proper tax planning in your plan in place. And so that's what we stress with clients. Are your assets talking to your plan? And if one of you passes away, are you taking the steps you need to take? And sometimes there are steps that the government has already allowed us to do. It's not even special planning. It's just using the exemptions are available. Most people pass away and don't use their estate exemption.
Wow. This could be especially problematic if you have a privately held business or a small business, because a lot of times that's illiquid. And
yes, it can be devastating because the taxes are typically due within 9 months of the death. The exemption has to be filed within 9 months of the death. As you said, if it's not liquid, something's going to have to be sold to satisfy that tax bill. So planning is key to ensure that doesn't have to happen. Okay.
So in other words, you talk about preserving the exemption. Is that called something? I mean, like the state tax exemption for each spouse? Is that?
Yeah, what we're talking about is every spouse gets a credit. So your credit, and that is what's changing every year. And the problem is it's not automatic. So it has to be filed with the 706 estate tax return. Mm-hmm. It has been my experience that most people I've met have never heard of a 706. I'm not a CPA. I'm also not a tax attorney. I do have a tax attorney in our office. We do handle those type of things. But it's been my experience, most people have never heard of a 706. So when someone passes away, if a 706 is not filed to preserve that exemption, then the spousal exemption, then it's lost. Okay. The other thing that's lost is most clients, because the exemption is so high right now, they're not going to use all of it. So husband passes away, say a family has, $3 million in assets, and husband's half, say the 706 is filed. We're not only telling the government that exemption has been used, but you're also able to preserve what wasn't used. So you're able to preserve the rest of that 12 million, though, so that when she passes away, if there is an estate tax, we can use not only her exemption, which may have dropped by then, by the way, depending on the law, but we can also use what husband didn't use. And that's called a deceased spouse's unused exemption. The term a lot of CPAs and attorneys use is a DSUI.
DSUI?
Yeah, DSUI, I know.
Okay.
That is what most people miss out on, because a lot of people say, well, hey, the estate exemption is so high, I don't have 12 million, I don't have 24 million, I don't need this. But again, I would remind them, the exemption has been as low as $675,000 just in this century alone. So the question I like to ask is, if you think there's a chance there's going to be somebody in office when you or your spouse dies that likes taxes as much as they did in the year 2000, then it's something you need to plan for and at least consider. So we go over that with all our clients, whether or not it applies, whether or not it's something they want to take advantage of, but we want to make sure they're aware of where we are with the law right now. And so that's when it comes to tax planning, I think that's a big starting point.
Okay. So making sure that they are, at least from a state tax standpoint, taking full advantage of each spouse.
Yes, sir.
Because when the rules change, you're going to be able to, you don't know what the future holds. Doing the best you can within the rules of the game today.
That is right. A lot of people ask, well, can I lock all this in? Well, traditionally, you can lock the technique in, but you can't lock the amount in that it's going to be. And, as we all know, there's a lot Congress has done over the last few years that we've said, well, that will never happen. And it has happened. So the other thing I would point out is too many people think, well, I'll have plenty of time to plan. As we saw 2 Octobers ago, there was some major tax legislation that didn't pass, but it was very close to passing. Had 2 senators not stopped it, it would have passed and it would have been enacted quickly. So there wouldn't have been the time needed, at least in my practice, to contact everyone and get them to do the plan they needed to do. So we don't always have a lot of lead time on this.
That's right. That's right. And also, unless they have a crystal ball and I don't, I don't know when my estate plan is going to be needed.
That's right. That's
I got no idea when I'm going to go.
We know it's going to happen, but we don't know when.
That's right. That's right. Yeah. So let's say preserving each spouse's estate tax exemption. What are some other things that people need to think about when it comes to higher end estate planning for wealthy people?
I think the most overlooked area of estate planning is protection for future generations. I think this is what's been missed, in addition to probate, which we could talk about as well. But I think the protection side of it, unfortunately, most Americans are going to leave their wealth to the next generation in a way that's called outright, meaning that it's going to be in that child or in that beneficiary's name. Now, a lot of people, traditionally what you see, and by the way, I review plans from all over the country. So it's not just South Carolina, it's Ohio, it's California, it's Kentucky, it's whoever. We have a lot of people move here to Charleston, so we get to review a lot of plans. And in my industry or my area of the law, the tradition has been to leave wealth to children in what's called sprinkle trust. That would be typically the advanced planning. If you're not leaving it to them at 18, you're leaving it to them in stages, like say we're going to leave a third to the child at 25, a third at 35, and a third at 45. If you look at most planning that people paid good money for that's considered advanced planning, that's what it's going to say. Now, what's wrong with that? Well, there are a few things, and this is, of course, my opinion, but the first thing is I have 3 children. They're young. I have absolutely no idea what they're going to be doing at 25, 35, and 45. But if they're in trouble, if they have a creditor problem, heaven forbid they're getting divorced or sued, someone's coming after them, then I am going to be spitting out money on top of them and on top of their problems. The other problem is with the sprinkle trust, it eventually all gets out in their name. So if one of my children does very well financially, then my wife and I have just left an inheritance that is now included in their estate. So we have added to the tax problem for my grandchildren. So, to me, the best way to handle at least the generation, and some people go beyond and do future generations, but at least for my children, I want them to inherit it in a trust, not just because they're minors right now. That's going to protect them when they don't have the ability to control money. And even in the older teenage years, someone take care of them. But I'm talking about beyond that. The best way to leave wealth to someone is to leave it in some type of lifetime trust. And if you want to give them control, that's what you dispense. You dispense control, and then they can turn around and dispense that money. So if you think they're going to be responsible enough at a certain age, rather than spitting all the money out on them at that age, spit out the control. So you can say, hey, son, I think you're going to be responsible enough at age 30. I'm not going to take this bucket and dump it on top of you and whatever problems you have going on now and the rest of your life. Instead, I'm going to leave this bucket here for you. I'm going to put you in charge of it. And if you invest this properly and you keep what you can in here, obviously you can take the money out, but whatever you keep in here, nothing's bulletproof, but this is as close as possible. This is not going to be a marital asset. It's not going to be a creditor asset. It's a way to protect it. And then when you pass away, son, whatever you earned is not going to be married with this to cause you a greater estate tax problem for my grandchildren. So that's the number one thing that I see that is overlooked. And that's where we kind of set ourselves apart and help folks in that area.
That is really a good idea, because I have seen so many different types of trust, and most of them do just what you said at 25, 35, and 45. But what wealthy people tend to want to do is to put a moat around their wealth so that it's protected. as much as possible, right? And so if the child ends up getting their money in individual name eventually, they're basically draining the moat, so to speak. But what you're talking about doing is giving the person the ability to have access to the wealth, but still having a moat around it, protected maybe from creditors somewhat, and from divorce, from litigation, and maybe estate planning as well.
Yeah. I'll give you a quick story. I had a lady years ago die in her 90s, and a son came in, and we told him how she had set the plan up and that he was going to receive it in trust, and he was going to be in charge of it, but it was going to be in trust. And he said, well, I don't need that. And we said, okay, well, you're the trustee. So at some point, if you want to distribute this, you can do that. But we think it's a good idea to keep this protection. He called back, I think, a month later during the administration of her estate and said, guess what? I'm getting sued. And we said, well, it looks like your mom knew what she was doing. So, the inheritance is not going to be a part of that lawsuit. It's a good idea to keep that trust. So, yeah, it really, really works well.
Yeah. What's this called? They're
just, in a general legal term, it'd be a lifetime inheritors trust. In our firm, we call them asset security trust because it gives the client some peace of mind that those assets are have greater security than they would if they were just in their children's names.
Okay. All right. Perfect. Mm-hmm. So is there anything else in the what are some of the other things that need to be thinking about if they have their estate planning taken care of from spousal, and maybe thinking about the next generation?
Yeah. So a few things that can kind of eat into that estate. Along the same lines of what we were just talking about, some people go down further and they do what we call dynastic or generational planning. And they say, if any of my beneficiaries receive inheritance, they're going to receive it in these type of trusts. And that, as you were talking about earlier, that helps preserve it. There's also ways to ensure that once the estate tax is paid, if there is an estate tax at the first two deaths, the husband and the wife, then that can grow estate tax free after that. So there's some things you can add on that help with that. Another big thing, kind of to your point about spouses, this is typically where I get us guys in trouble. The statistics show that the husband is going to die first and that the wife is not going to remarry. However, husbands are 4 times more likely to remarry. And then there is a chance with most people's planning or lack of planning that the new wife comes in and she ends up with the assets. I've seen, just to give you a quick story, I've seen that in my family. When I was, my great grandmother passed away in Griffin, Georgia when I was in 8th grade. She left everything to my great aunt because my great aunt and her husband took care of her. The problem is my great aunt passed away right after that. My great uncle remarried and passed away shortly after. And now we had a lady no one knew that had everything in the family. So there are ways to prevent against that. And you can basically say, hey, we as a husband and wife, we're fine with the surviving spouse using it, spending it, gifting it. But we want to put some protections on there that say that we decided where it was going to go when the last one of us died. We're not going to add someone new to the plan. So that's one way to protect the assets I think is often overlooked. Another way is just keeping it out of, the government's hands. And I'm not talking about particularly tax planning. I'm talking about government control. I'm a big, small government guy. If the government can stay out of my life, to me, it's a happier life. But for some reason, the majority of people are okay with sending everything they've ever worked for through the government system called probate. Probate is different in every state, but it is still something in every state that is completely avoidable. But most people are going to end up going through it, and because that's because of a lack of planning. A lot of people say, well, probate's not a big deal. Well, to me, it's kind of like the DMV or a hospital. I don't care how nice your experience was. I don't want to go there if I don't have to, So with probate, I think the most overlooked, there's 2 types of probate. The first is the living probate, which most people have never heard of or had a little experience with. The second is the death probate, which is what most people think of when they think of probate. And probate is a Latin word. It means to prove. What are we proving? We're proving the will. So a lot of people come to me and say, hey, my dad passed away. I'm the executor or I'm the personal representative. What do I need to do? And I have to tell them, well, you're not the executor. You're not the personal representative until the court says so. Because in most wills, you'll notice it says nomination of executor or nomination of personal representative, because the will has to be proved by the judge first. The judge has to say, this will is okay. And yes, I'm going to go along with the wishes here and appoint this person. At the end of the day, the judge has the ultimate say on that. We have some good judges in our state. We have, here in Charleston County, we have a judge who's an attorney, does a great job. But I've heard even him say, hey, if you can avoid the probate process at death, you should avoid it. In South Carolina, our judges don't have to have law degrees or advanced degrees or college degrees. It's really an election. So,
they don't have to have law degrees?
That's correct.
In South Carolina, they don't have to have law degrees.
This is true.
A judge.
Yes. And this became a problem a few years ago in an election when we had one judge that had them and one that did not. And it came real close where the judge without the law degree or candidate almost won. So for me, if you can just avoid that whole the other problem is the executor can charge up to 5%. The personal representative can. So,
wow.
Yeah. And, if it's a court appointed some person, there's a good chance they're going to take that fee. So I'm not a big fan of that. There's also an assessment. I don't think it's large, but it can be depending on the size of the estate. I mean, it can get up to several $1,000s for the court fees. Additionally, anything going through the probate is public. So people can find out what your assets are. And they may be somewhat, back to your point, Jeremy, about the businesses, it may be a situation where you've passed away, you have a business, your spouse is wanting to sell the business, and now their competitor can find out exactly, what the particulars are about the business before they make an offer. That's what always concerns me as a business owner. Another thing to think about is you're essentially asking the world to, if they have a beef with you, to file a claim, and you're going to pay for that party. You're going to allow them to file the claim. You're going to pay the claim if it needs to be paid. If you don't go through probate and they want to file a claim, they're going to have to deal with the probate. They're going to have to pay these fees. So I once heard probate described as a party that you throw, or a lawsuit that you throw for your creditors on behalf of your creditors against yourself. And to me, if I can help my clients avoid that, I want to do that. The other thing to think about is that living probate. This is what I think is really overlooked. And when you talk about some things that can eat into the estate, there's 100% chance we're going to die. New federal funded study shows, but there's also a 75% chance we're going to be disabled before we die. And with disability comes incapacity. So I've seen that more and more. I'm seeing clients lose their faculties and get to the point where can't make good financial decisions. The problem is what's been relied on in the past with estate planning completely because of will planning is the power of attorney. Think about it. If you have a will, that will does not become effective until you die. So the only incapacity planning you can have with a will, and I'm not talking about long-term care planning, that's a whole nother topic. I'm talking about financial control planning, is a power of attorney. That's it. Power of attorneys are supposed to be effective as long as you are alive. But we know the reality is there are financial institutions that are concerned about taking the liability on of honoring an older power of attorney. So say a 5-year-old power of attorney is what I typically see, that may or may not be the client's wishes anymore. And they're concerned about getting sued by the client. So their concern is mom names son power of attorney's son comes in and says, hey, mom's out of her mind. I need to get access to her accounts. Give me the money. They give him the money. She comes in the next day and says, are you out of your mind? I haven't talked to my son in 3 years. I've done 2 power of attorneys since I did that old one you just honored. My son just spent the money you gave him. I'm now going to sue you for that money. So we run into the call we get is, hey, I'm down at the bank trying to get mom's power of attorney honored. They're not honoring it. What do I do? You have to go to probate court. And at probate court, you're requesting to be picked conservator. If you're not picked conservator, the court is going to appoint someone and they're going to charge a percentage that I can assure you, Jeremy, I don't know what your fees are, but I know they're not as high as conservators. And a lot of times you're dealing with someone that doesn't know how to manage money, not in the way that you do. So that becomes a real danger. And they only, in South Carolina, they only have to report back to the court once a year how they spent that money. So,
wow. Well, a lot can happen in 12 months.
Exactly. So that is why I'm such a big believer, not only in living trust, but also making sure the assets, to the extent possible, are in the trust, because the trust dictates what the definition of incapacity, how it's determined, and it doesn't involve asking a court or someone, doctor or judges that the client may not have met, whether or not that capacity is legitimate or not. And so then the trustee is able to step in. And here's the call I've never gotten. I've never had someone call here and say, hey, I'm the trustee of Dad's trust. I'm at the bank. The trust account's here. They're giving me problems. They're not honoring this trust. I've never had that call, because there's really not a lot to argue about. So it really saves the family time, money. I'll just give you a quick story on that. I had a lady who was giving money to people she shouldn't be giving it to. The police department was trying to help her. They found out about this. They were taking her affairs to court to get a conservator appointed. But I was able to tell her children, hey, your mom did a trust. You are her disability panel. Vote and determine whether or not mom has financial capacity. They voted. They stepped in as trustee, and then I was able to tell the court the police department, listen, I appreciate what y'all are doing. Good news. The family is now in control of the money, and we don't have to go to court. Had she not had a trust, we would not be able to do that.
Yeah, and then go to court, and then you may have a judge that doesn't have a law degree, presiding over stuff like that.
That's right.
That's insane. That just sounds crazy.
So the family was able to come back later after she passed away and said, we're so thankful mom had this trust, because we were able to be the ones helping her through the years. And there was actually an inheritance left afterwards.
Wow.
Wow.
So like you mentioned the power of attorney, they don't want to honor something that's over 5 years old. Does that not hold true if you have a living will, or is that what you were saying earlier?
So what I was getting at is a will is not going to be effective till you die. So to help with that, most people who do will planning, and we're the same way, we do will planning for clients if they want will planning, but that's typically going to be younger couples who are just starting out. So we're going to do the will and we're going to do the power of attorney. And what I'm going to tell them is, it got so bad in our state that in 2017, the legislature passed a law to try to force banks to honor these power of attorneys. Unfortunately, there's certain language that has to be in that power of attorneys, and banks know that if they're not in there, they don't have to honor them. So a lot of power of attorneys out there don't have that language. So I just think there's a greater chance that a trust is going to be honored rather than a power of attorney. There's a great, and this isn't just me saying this, there's several articles in the Wall Street Journal, the New York Times, one of which is called "Why Is My Power of Attorney Powerless?" And what it says is these institutions, and these aren't, bad, some bad bank or something. These are well-respected, good institutions that are just tired of taking on liability and don't want to be, I think the Wall Street Journal article quotes that they don't want to be a party to fraud. They don't want to be giving their clients money to someone who may have been power of attorney at one point, but are no longer the power of attorney. And so that's where their concern comes in. So, if someone does have a will and they want to stick with a will and don't do a trust, I just advise them, hey, keep that power of attorney fresh. At least every 3 years, I would do a new power of attorney. And another way to get around that or to help is if you have large accounts with a certain investment firm, a lot of times these investment firms have their own power of attorneys. I'm talking about like a Fidelity or, a Merrill Lynch or whomever, whatever platform your financial advisor might use. They might have their own internal power of attorney, and you can register that with them. And it's less likely to be turned down.
Okay. So these trusts here, there's language inside that trust that would give, there's power of attorney language inside the trust. That's what you're saying.
Well, the trustee is essentially acting like a power of attorney. And the reason there's not as much hardship when dealing with a bank or financial institution when it's a trust-owned situation is the account literally says that it's owned by the trust. And then the trustee is walking in with what's called a certificate of trust. I describe it as the driver's license of the trust. And it says, okay, I am the trustee of this trust. So then the bank or financial institution knows, okay, this is completely legitimate. This is the person that is currently in charge of that trust. So essentially what I'm saying is the financial institution has a lot more faith in those documents than they do in a power of attorney that could have been changed the night before. So that's why they feel a lot more comfortable honoring trust than they do power of attorney.
That makes sense. What is it like? just to kind of dig a little bit into that, the driver's license for the trust, for instance, like if this lady, became incapacitated in some way, how does that transfer the driver's license from the person who got incapacitated to the?
Great question. I would say traditionally most trusts say the opinion of two doctors, they determine incapacity. And once that incapacity finding has been made inside of that trust, it says, okay, this is who I've named as a successor trustee. So if it's my brother, then the law firm helps appoint that brother it's typically a 2-page document as the new trustee. And so once that finding's been made, now he is officially the trustee. It's a very simple process. And then he walks in, is able to show the bank, okay, here's the trust, says I'm in charge, here's certificate of trust. And by the way, the institutions are typically going to want to see some more pages of the trust to show that process has been done or the findings have happened. But that's typically how it works. Now, I will tell you, I have a different opinion on how those findings should be made. I typically advise people not to use two doctors. And here's why. It's been my experience, one, doctors are extremely busy. Two, it's hard to find two doctors that know that patient. And there's a lot of times there are doctors concerned about liability in making that declaration. So quick story, I had a client who was in an Alzheimer's unit of a hospice facility. And it took 8 weeks to get two doctors to determine or fill out a finding that she was incapacitated. Well, she was obviously incapacitated. What I like better, if it works, is a lot of my clients say, you know what? I have 3 adult children. I trust their opinion. I'm going to name my spouse and my 3 children, and they're going to vote. So that way, the example I always give, if dad is paying the mailman $10,000 a day and has essentially lost his mind, wife calls and says, we've got to do something about this. She gets to panel together. They all talk to dad. They vote. And they make a determination that dad is not medically incapacitated, but financially incapacitated, which the trust allows for. And then the successor trustee, typically the wife, is now appointed. Okay. So that's one way of doing it.
All right. Makes sense. I'm going to jump back a little bit. Sir. Gray divorce. There's a lot of, like you said, if his wife passes away, they're 4 times more likely to get remarried.
Right.
And then, this happened in my family too, right? My grandma passed away and he remarried. What are some things that the original family may need to do or the husband may need to do to possibly support his second wife, but those assets or businesses or whatever need to go to the original family? Or how to think about this process?
Yeah. Well, the key there is nothing's foolproof. However, most people don't go to the extreme when it comes to remarriage protection. The extreme would be if a husband passes away or a wife passes away, the surviving spouse cannot be the trustee. We have a third party that's in control. That's the number one way to make sure that it only stays in the immediate family. But to your point, how do you both provide for the immediate family, but also provide for the new spouse? That is typically when, the portion that, or we'll call it husband's half, that's where he comes back in at the death of his first spouse and plans for the second spouse with some of those assets. And, if he wants the family involved, all the better, as long as there's, we don't want to create problems where there's not problems, but there are definitely ways that you can accomplish both of those things, either pre-death or post-death planning. What I found the problem is if you wait until post-death, first spouse, there's a whole lot of emotions going on. A lot of times the statistics show, believe it or not, that second marriage happens pretty quickly.
Yeah.
Now, in our defense as men live longer if they do remarry. So, so it is a lot of people will say it's kind of a survival thing. But that's typically how it works. So I think it's got to be, it's just, there are hard conversations that have to be had. And I found a lot of times they're conversations that haven't been had. And so sometimes that happens in the attorney's office. So finding out what their concerns are. And like you mentioned, Jeremy, it's happened in your family. It's happened in my family. We're not alone. I mean, this goes on a lot. So acknowledging that and talking about, okay, how do we want to control that? How do we want to provide for the second spouse? How do we want to ensure there's something for the family? One way is making sure, I call it, like my granddad used to call it, let's put a little sugar on the cookies, make sure we dispense a little bit at the first death so that the family is not waiting around for the second spouse to pass away. I find, so you just give them a little something there, or it may be a large gift, but go ahead and make a transfer at that first death rather than waiting for the second spouse to pass away. Because what happens is, if you don't, especially if you have a case where the wife is much younger,
mm-hmm.
the man's children start growing resentful of the new wife because they're thinking, I may never even see this inheritance.
Right.
So I strongly advise, if you're going to provide for the second spouse in a big way, make sure you're also keeping in mind the children who may or may not be able to enjoy that inheritance if they have to wait to the second death.
Yeah. I mean, just a lot of times people are just so against talking about it.
Mm-hmm.
Really. I mean, even my wife, I bring up stuff like this and she kind of wants to shut down with it.
Mm-hmm.
It's too painful or to think about. But the reality of it is that's life, and it's also death. So it's going to come to us all, and be thinking forward in those difficult situations, because what ends up happening if they don't deal with it, it really causes some problems, or can cause problems down the road. So we say it is unburdening the future generation.
Yeah. If you don't deal with it, someone's going to deal with it. And you're right, Jeremy. What I see, what usually gets people in my office is not because they've said, okay, I'm going to have this conversation. It's because they've experienced it with their family. So something's just happened. There's been a death, there's been incapacity, there's been divorce, there's been something going on. And that's what drives them to actually finally have that conversation.
Yeah. Okay. Well, makes sense. What else should people be thinking about in regards to estate planning and preparing, not only protecting their stuff from their assets from creditors and being sued, but also being thoughtful stewards of the next generation?
Yeah. So, when I think about planning, I think it really involves three things. And I didn't come up with this, but love, money, and control. Most people who come in my office, they have the first two. They've got love, they have some assets, but they don't have the control they want. So really determining what type of control, and control, it can be a good thing. It's not, a lot of times people hear control and they think, well, that's bad. Well, there are ways to protect your family and preserve your legacy. And to do that, you're going to have to use some level of control. The best definition I ever heard of estate planning was this: while I'm alive, I want to control my property. If I become disabled, I want to take care of me and my loved ones. I want to give what I have to whom I want, the way I want, and when I want. And I want to save every last tax dollar, legal fee, and court costs legally possible. And so if you key in on some of those, we've talked a little bit about the control and incapacity, the avoiding probate at death. We talked a little bit about the estate taxes, but as you mentioned earlier, there are a lot of folks out there that have some large assets, whether it's their business they've sold or about to sell. I think it's a really good idea to look at how settled you are in your assets and how committed you are to transferring it to those next generations. And if you are, that's going to take some work and some thought to really decide how you want to transfer that. And it may involve transferring some of that in life, whether that's transferring it to each other, spouses, an irrevocable trust, and still maintaining a level of control, or whether that's going ahead and giving some of that to children now. We're in unprecedented times. We talked about the fact that you can die with 12 million. And if you're married, you can die with 24 million right now for the next few years without having an estate tax. You can also give that away.
Yeah.
Once that goes away, that opportunity is gone. And I personally don't think we're going to see that again in our lifetimes. We may, but I highly doubt it. So what a lot of people are doing now is they're kind of what we call squeezing and freezing the value of assets. So Maybe it's a business. Maybe it's, hey, I think there's going to be a liquidation event at some point down the road. I know the value of my business today. Why don't I go ahead and squeeze that value and freeze that value by getting the discounts I can by an appreciation or a valuation, and then giving that to someone in my family so that it's out of my estate. So they're not dealing with the estate taxes on it when I die. So in other words, the growth, even if it's not a business, even if it's just your investment account that, or your real estate, getting the appreciation out of your estate by giving it in life. That's something I think a lot of people should consider, and there's some downsides to that too, but, with control and basis and that sort of thing, but there are some things to go through and consider.
Okay. So in other words, like if possible, take advantage of the $12 million while you're living.
Yes.
Give that under a lifetime exemption. Is that what I'm the terminology? So and so that grows in the next generation's assets. So it doesn't have to be subject to probate in the future. I'm not probate, estate taxes in the future.
Exactly. Okay. So the way our tax law is working right now when it comes to estate and gift is the exemptions, the credits are unified. So if I want to, let's say I want to give away $2 million and I don't want to pay a gift tax on it, I want to give my child $2 million, I can literally give them that $2 million and not pay the gift tax. Yeah. Now, what I'm doing is I'm filing a gift tax return and I'm telling the government, hey, you said I could die with 12 million. Well, I'm giving 2 million of that coupon, that credit away. So now I can only die with 10 million. But think about it. I didn't just get 2 million out of my estate. I got whatever that grows to over the rest of my life out of my estate. So if that doubles when I pass away, rather than having 4 million in my estate now that my kids are going to have to deal with for taxes, that 4 million is out of my estate. So now the downside of that is if they sell it, they have my basis. So,
yeah. There's no step up in basis on that.
That's the poisonous pill. Right now we have stepped up basis. If you inherit something and you sell it, as long as you sell it for the fair market value at the time of death, there is not going to be a capital gains tax.
Right.
When you give, you take away that whole stepped up basis. Now I'll tell you, thankfully this did not happen, but Biden had in his green book, his tax book, their plan was to eliminate stepped up basis, which, and if there's anything I can encourage your listeners to be on the lookout for in the next several years, is when you hear this concept being proposed, it would have devastating consequences, not only on most estates, but anyone that has any property, whether it's just a home or a bank account. It would affect every American that had any assets. It's a terrible idea. I pray that it never passes, but it is something people need to be mindful of if it does or if it's close to passing.
Wow. But the only way that I could see that, if they would have to get rid of the estate tax, I mean, you would have to you can't have both, because otherwise you would just be slaying the next generation.
Right. You would think, right?
Yeah. Yeah, really.
I mean, I know Canada has something similar to that already, where they've eliminated stepped up basis. And I'm not a Canadian attorney, but so it has been done, but hopefully it never happens here in America.
Right. Okay. All right. I got you. What are some like states that, sometimes you have a trust in Wyoming or Bahamas, or so you get a domestic trust and a international trust. I mean, I've heard these things. Well, what are some advantages and disadvantages of those?
Yeah. So, using other states, I think, can be a good thing. I'm actually licensed in the state of Wyoming. I've used Wyoming companies for my clients for years. The advantage in that case is a primary advantage is estate tax planning. So Wyoming has a close LLC statute, close CLOSE. So you can have closely held business interests that have restrictions, typically among families, is how we set it up, so that when someone passes away, the assets in that company can be discounted. Whereas if they were just in their name at death, if you had a $10 million account and it's in your name, when we fill out the estate tax return, it's going to be $10 million. If it's in a company that can receive discounts for the way it's set up, can be valued less, sometimes we see 30% discounts. So rather than it being a $7 million situation or $10 million situation, it's $7 million. So we're able to get money out of your estate just by having it in that company. There's also some asset protection opportunities. There's nothing bulletproof out there, but there are ways to put some barriers between you and potential creditors. Not if you know of creditors, of course, but just for the future, make it harder for people that are trying to come after you and your assets that don't have statutory protections. In South Carolina, our statutory protections are very weak. You only have $50,000 adjusted for inflation homestead exemption. So what that means is if you have a paid off home, only $50,000 of that equity is protected if the insurances don't cover whatever threat you have. Now that's up to 2 title holders. So you could get if it's a husband and wife, that's 100,000 plus. But still, especially in a place like Charleston, where very valuable homes, that's not much protection.
Not at all.
I think retirement is pretty protected in South Carolina. I think at least over $1 million or $1.3 million for IRAs. ERISA plans are generally protected. We've had some bad case law recently, but so 401ks. But the big hole in most people's plans when it comes to protection is non-qualified investment money. We have only a few $1,000s. I think it's $5,000 protection for cash and investment accounts. So basically your creditor, if they win, they have access to those accounts. And that's not a good thing. So that's where we've seen other state law help in that. What you were alluding to was the domestic asset protection trusts, and that you've heard about those and you see those. And here, South Carolina does not have a domestic asset protection trust in our trust code. We don't have that. Places like Nevada and Wyoming do, and they have very good trust planning. I have some clients that have used those, not through us. They've used other attorneys for that. My concern on domestic asset protection trust, and this is just my personal preference, is that there has been some bad case law in other states where not foreign out of America, but foreign other states, trusts were used for their domestic asset protection trust laws, and they were not honored. I don't think there's any question if you're a Nevada resident and have a Nevada DAP that Nevada DAP is unless there's some outstanding circumstances, likely going to be upheld. But it's less sure if it's a South Carolina individual with a Nevada trust, whether or not South Carolina courts would honor that. We don't know. We haven't seen that. I think there is more favorable opinion when it comes to LLCs that are foreign. So we know in our federal district, we've seen judges say, okay, there's a Virginia person, a citizen, and they have a Delaware LLC, and that Delaware law was honored. It's not always that way, but much better chance, in my opinion, than with the trusts.
Okay. I would think about as far as the having been properly insured. I found that the easiest way and the least expensive way to protect yourself in that realm is with umbrella policy.
Yes. Yes. And I would say as long as the client is aware of the fact that it's not foolproof. So I'm like you, I'm a big believer. I'm going to suggest every one of my clients gets an umbrella policy. I'm not an insurance person, but I'm a big believer in, hey, we have a lot of 1-800 attorneys in this world, and nothing wrong with that. I realize,
1-800 and dial about any number after it repeated for the next 7 digits. You're probably going to get one.
Yeah. So there's a chance if you get my biggest concern for my clients are car wrecks. So, what happens, what insurance covers. And what I'd like to tell clients, again, not an insurance expert, but, when you think about life insurance, there's one condition for a life insurance policy to pay out. It's pretty easy to define what that is. It's death. With an umbrella policy, it's not as clear cut. Just because you got sued doesn't mean it's going to pay out. But I also tell my clients, most people out there don't have umbrella policies. So whether or not that umbrella policy pays out at all, you're still a leg up because you have that option, and most people don't. So I have an umbrella policy. I believe in them. I think it's a good start. Yeah. A lot of my clients, though, like the tax planning opportunities and some other what I would call hurdle opportunities with some of these other entities. Yeah. And that's where that kind of comes in. But you're exactly right. Boy, there's nothing wrong with having a good umbrella policy as a good first line of defense.
Yeah. It's like adding an airbag.
That's right.
It's like adding an extra airbag in between you and whoever's trying to sue you. And then what the more sophisticated things that you're referring to, I think of that as just making the walls higher and thicker to help deter people from trying to overcome those to get to your money.
That's right. So hopefully they will take that insurance check happily and not try to come after anything else.
That's right. And typically I would think that other attorneys who are looking to do that, oh, that's the lowest hanging fruit. Let's just get that and go on.
I think you're right. It's human nature.
That's right. Yeah, that's right. That's right. Anything else top of mind as far as that you've dealt with, or some examples and to think about when people are trying to look to protect their assets and guide their wealth to the next generation?
Yeah, I would just encourage people, as we were talking earlier, just to have that conversation with their estate attorney, because most people we know from statistics are not having these conversations and not doing the planning and not keeping it updated if they do.
Okay. Sounds good. Well, Tripp, how would someone get in touch with you? Because, I mean, you've shared some great information talking about second marriages. You're talking about the disadvantage of having, even if you had a trust where the child gets the money at 25, 35, and 45, it's still, they're going to create their own problem. Maybe they may not be adequately able to use that money in the proper way. Yeah. Or if they have, they're taking that moat away and putting it in their own bucket. Mm-hmm. And so how would they go about contacting you and your firm to help them go through this process?
So our website is wileslawfirm.com, and that's my last name, Wiles lawfirm.com. My email is tripp@wileslawfirm.com. Our phone number is 843-718-0232. So be more than happy to email. There's a way to get in touch with us on the website or take a call, and we do a no charge consult. So happy to sit down and talk with you about your concerns and then give you some solutions.
Yeah. Well, thank you very, very much for your time here today. You shared some great information, and I thank you very much.
Thank you, Jeremy. I appreciate you having me.
Gentlemen, this has been fantastic. Both of you did a great job. Thank you so much for all the information. Jeremy, of course, thank you for facilitating this. And our last thank you goes to you, the listening audience. Thank you so much for tuning in and listening to the Retire Happy podcast with Jeremy Finger. If you have not subscribed to the podcast yet, please click the subscribe now button below. This way, when Jeremy comes out with a new podcast, it'll show up directly on your listening device. And we humbly ask you to share this podcast, rate it, and leave a review, as this actually does help others find the show. Again, thank you so much for listening today. For everyone at Riverbend Wealth Management, this is Eric Johnson reminding you to live your best day every day. And we'll see you next time.
Thank you for listening to the Retire Happy podcast with certified financial planner Jeremy Finger. If you have any questions, please visit us at www.riverbendwealthmanagement.com or call us at 843-970-1043. And remember, click the subscribe button below to be notified when new episodes become available.
Investment advice offered through Stratus Wealth Advisors, LLC, a registered investment advisor doing business as Riverbend Wealth Management. The opinions voiced in this podcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision.